everyone. Welcome to our masterclass about intellectual property law. We've got some panellists here today from Bristows to chat through their expertise, their route into intellectual property, and lots more. So please do get involved throughout the masterclass by asking Q&As using the Q&A feature in the Zoom tool, and I'll be taking a look at these and posing these at the end. But please do get your questions in as soon as possible. That's really useful for us. Before we get started, I just want to outline some learning outcomes. So by the end of the session, you should know how to break into this practice area, know more about what the work of an IP lawyer involves, and know a bit more about the key issues that are facing the practice area right now. Just as a starting point, I've got a couple of house rules just to note. First and foremost, as I mentioned, please use the online question tool. Secondly, just to note that the masterclass will be recorded, and a recording of the session is going to be sent to all registrants at the end of the session. It's also going to be available on our YouTube channel very shortly too. Please also feel free to post about the masterclass on social media using the hashtag LCN Masterclass. And finally, I just want to note that we've got some fantastic masterclasses coming up over the autumn term. So if you're interested in coming to more of our masterclasses, I'd recommend checking out the events page on Law Careers.net. For example, our next masterclass is on private equity, and that's on the 1st of October, which is 2 Wednesdays' time. So just to get started, I'm going to launch a poll for all attendees, and that's just to get an idea of who's joining us today. So this is a poll about your stage. So what kind of stage have we got today? Looks like we've got a range, quite a few postgrads, some non-law, and quite an even split across first, second, and third year of uni, and a couple of people in work too. So that's good to know. And then also, just as a starting point, I'm going to launch a second poll about how much do you know about IP already? Just nice to see and hear about at the start of the masterclass, and hopefully we can teach you a bit more about that today. Okay, it looks like we've got a couple of people who know absolutely nothing, quite a few people who know a little, so hopefully you'll learn a bit more today, and then a couple of people who say they kind of have a bit of expertise in this area, so this should be interesting for you too. Great, so I think it's time to start the conversation with our panellists. So I'm just going to start by letting each panellist just go around and introduce themselves as a starting point. Can I start with you, Rachel?
Yes, so my name is Rachael Cartwright, and I am a senior associate in the patent litigation department at Bristows.
And Luke?
Hi, my name is Luke Norton. I'm an associate in the patent litigation team at Bristows.
Hi, my name is Fariha, and I'm an associate in the patent litigation team, but I've just very recently qualified.
Fantastic. Thanks, everyone. Great. So just to start off with a brief introduction, I guess, some introductory questions. I'm going to pose this first one to you, Luke. What are the different kinds of intellectual property lawyers, and what are the different parts, I guess, of this practice area? Just to give an initial overview, maybe how does the transactional side differ to the litigation side?
Yeah, sure. I think as a starting point, one of the things to note about intellectual property as a kind of practice area is that there are lots of different types of intellectual property, and in many cases, IP lawyers will either focus on one of those types. So, for example, all three of us kind of focus mostly on patents, although we will kind of dip into the other types of intellectual property. But in addition to patents, there's copyright, there's trademarks, designs, trade secrets, there's other related rights like domain names. And so some IP lawyers will be kind of more generalists, and their practice will kind of be across that broad scope of all of those intellectual property rights, whereas others will be more specific and will really focus on one or two of those IP rights. In terms of the kind of types of professions, I suppose, which might be thought of as IP lawyers, there are kind of barristers who practice as IP lawyers and who focus on intellectual property litigation. There's also trademark and patent attorneys who are a kind of lawyer who focuses on the securing the registration and maintenance of IP rights. And then there's solicitors, which all three of us on the panel are today. And kind of within the solicitor route, there are different types of IP lawyers as well. So all three of us are litigators, so our focus is on disputes and in particular relating to patents. But there are litigators who focus on trademarks or on copyrights or on those various other rights. And then in addition to that, there's also the kind of transactional side and the commercial side, where solicitors will advise on the intellectual property aspects of deals. So the buying and selling of a company, if one of the key assets of that company is the intellectual property rights, it'll be really important to get IP advice on whether or not that intellectual property is properly held, is being transferred appropriately, and lots of other complicated issues. And then in addition to that, the nature of intellectual property rights, some IP rights, like patents, they themselves will be licensed. So it's not just kind of the transactions in the kind of broader sense of what you think of in terms of buying and selling companies, but also, there will be very complex licensing arrangements in place where solicitors will be advising and negotiating those contracts. So it's a real broad spectrum with lots of different areas. And as I say, some people will be kind of more generalists across the board, and then some will be much more specific.
Fantastic, thank you. And then in terms of how does that fit into the everyday, Rachel, could you tell me a bit about that?
Well, I think actually IP rights kind of are all around you every day. And I think it's something that people maybe don't appreciate so much. So just by way of example, I'm sure most people, if not everyone, will have a mobile phone in this day and age. And the way that mobile phone works and connects up to the networks, all of that technology will be covered by patents. The way that phone looks will be covered by design rights. The companies that make those phones will have trademarks. Then, any adverts that you see, the brands will be covered by trademarks, design rights, and of course, books that you read and any manuals that you use, instruction manuals or things like that, will be protected by copyright. Music's protected by copyright. So really, IP rights and IP law proliferate everyday life all the time. And this is why companies fiercely protect those rights. And you have the hard-nosed licensing teams that Luke was talking about, and why often lots of detail is hammered out with respect to those rights when you are have big corporate deals and things like that. They're quite integral actually to the way that life works nowadays.
Amazing, thank you. It sounds like it's a very kind of broad practice area with lots of different areas to get involved in and lots of different specialisms, which I guess brings me on to my next question, which is for you, Luke. I guess, how does that work in terms of your work? Do you sort of only specialize in one specific area, or is there scope to kind of look across broader issues?
Yeah, I think we as patent litigators, I think we are quite specialist. So we generally will focus in on patents in particular, and each case is often takes many years and will involve lots of really getting into the nitty-gritty detail of that patent and the relevant technology. But that's not the case for all IP lawyers. I think particularly in the kind of more commercial transactional space, that there is a bit more of a kind of generalist approach. If you're advising on the buying and selling of a company, all of those rights that Rachel mentioned there, they'll all be kind of a part of that deal. So it will be important to ensure that all of the relevant copyright is properly been recorded and assigned by employees, and it'll be important to note that all the patents are registered in all the key jurisdictions. So their role does kind of pervade a kind of wider spectrum of rights.
Great, thank you. And then in terms of, I guess, breaking down by area of patents, kind of by area of clients, I guess, are there a specific group or sector that you would say that you work with primarily, would you work with clients? Sorry, for Luke. Yeah.
Okay.
Yeah, of course. I mean, I think it's generally it is quite sector agnostic, as Rachel said. Every kind of company today has intellectual property as a key asset, whether you're talking about big tech companies or restaurant chains or entertainment. Like, intellectual property is a key asset for them, and so it does pervade lots of sectors. Having said that, some sectors, I think, have more of a focus on intellectual property, and it becomes not just one of their assets, but their key assets. So I think life sciences is an obvious example. The technology sector is another example where patents are a real key asset. You look at something like the fashion industry, that's an area where their key asset is their brand and their designs. So that will become their real focus. But it is broader than that. I mean, I have advised, for example, asset managers, and in kind of thinking about investing in companies. And so they want to understand what they're investing in. And so they need to understand the intellectual property that they're investing in. So it is sector agnostic, and it isn't just limited to those areas which really focus on IP.
Fantastic, thank you. And then now I'm going to move on to look a bit about, I guess, the day-to-day life of what day-to-day work looks like. I'm starting with you, Fariha. Could you tell me a bit about what your day-to-day work looks like?
Yeah, so it definitely varies from day to day. But normally what would happen is you'd kind of get into the office, maybe open up your inbox, see what emails have come through. And I suppose you would just kind of catch up, see what you need to do for the day, check your meetings, probably get yourself a coffee at some point in between all of that, and then kind of sit down and get on with your tasks. And that can vary. So if you have kind of active litigation going on, it might be a little bit more fast paced. So you may see that, things are moving a bit quicker. So you might be drafting things and sending them out, or you might be reviewing things or going to team meetings. But maybe if you are having a bit of a slower pace, you might be doing different things. You might be reviewing, you might also be doing general kind of know-how, reading things, reading updates, case law updates, that kind of thing. So yeah, we have, I would say throughout the day, it really depends what matters you're working on. And also at Bristows, we have quite a lot of know-how sessions and just general kind of team meetings. So quite possibly over lunch, you might be in a know-how, and those kind of consist of different people across the firm giving presentations on case law updates or things that are going on in their matters. So yeah, and then after lunch, you'd probably continue to crack on with your tasks, things that you have going on. But yeah, it definitely varies. It can be busier and quieter, and you'd have different kind of tasks for those different periods of time.
Amazing, thank you. And then just sticking with you on this one, I guess as a newly qualified associate, would you be able to give a bit of an insight into, I guess, your journey into this area and how you came to be practicing in IP? What kind of drew you to the area?
So I trained at Bristows, and over the course of my training contract, you move around in different seats. And I was in patent litigation about a year ago now. And I think what kind of drew me into this particular team and this particular type of work was that I just really enjoyed the litigation. I quite enjoyed the fast pace of it. I also liked how technical it could be. And you end up learning about really kind of niche areas of tech or life sciences. And I always found that quite interesting. Like as a trainee, I would kind of see other associates and partners talk about things, and I would have no clue what they were saying because it was super technical. But I actually found that one of the reasons why I found it so interesting, and I was like, oh, I kind of want to be able to do that in a year's time. So I think that's why I found patent litigation interesting, because I was on quite a big litigation matter during my seat. And I just thought the pace of it, the kind of the tech aspects of it, and how also interlinked it is with other areas was very interesting to me. So we worked very closely with the competition team on our Frand case last year. So I quite liked the crossover. So yeah, I think just going through my training contract, having done the seat and then leaving the seat as well, realizing how much I enjoyed the technical aspects and the litigation, it was quite easy for me to then make a decision to qualify.
Amazing, thank you. And then I've just seen a question coming for the audience, which I think is kind of off the back of that, which is just asking, I guess, how you found the transition, and whether you're doing sort of similar tasks as you were doing as a trainee, or has there been kind of an increase in responsibility or an evolution in those tasks?
So I've only just very recently joined, but I think there is a difference in, I suppose, the way you're expected to be within your teams. So there is definitely some tasks that as a trainee you will probably still do as an NQ, but that's not to say that it's not, like, a lot of the training tasks that we do at Bristows, and naturally, like, you have quite a bit of responsibility, so you kind of carry some of those things into your NQ role. But I would say that people definitely want to give you more responsibility. So since being back as an NQ, I've definitely felt that I'm being involved in things at a more substantive level, because you're kind of now here for the longer term. So that's been quite good. So there is a difference. You do feel a difference, but at the same time, you've also been in this firm for 2 years. So it'll take some time to be being used to being an associate. And I think the work also increases as well as you go along that journey.
Of course. Fantastic. And then my next question is for you, Rachel, which is just about key skills. I think this would be quite useful for lots of the aspiring lawyers that are perhaps interested in this area of law. What kind of key skills would you say are really useful to thrive in this area?
Well, I think a lot of the key skills are the same as you would need for any career in law, in that you need to have an analytical mind, you need to have good attention to detail, you need to be able to prioritize and juggle lots of different tasks under pressure, because particularly in the area that we work in, you are in some quite high pressurized situations. With litigation, there are lots of deadlines, clients demand various things, the other side might do something that slightly changes deadlines and things like that. So you do have to be adaptable as well, I guess, in that sense. But one of the things that I think is really key to a career in intellectual property law is that you have to be interested and curious. It's one of the wonderful things about patent law, and I think it also is the case for copyright and trademarks and design rights, is that actually you get to learn something new every case. Sometimes every day you get to talk with people who are experts in their field. And that is something that I personally love. And I think that having the curiosity and the eager to learn all of those things will really help you in a career like this. So yes.
Thank you so much. And then I guess looking across those 3 different areas of patents and trademarks and copyright, Luke, could you give me a bit of an insight into, I guess, the main differences to how a lawyer, I guess, would approach those different areas, and how, I guess, those roles differ?
Yeah, I mentioned before how kind of on the kind of advisory side or the commercial side, it will often be the fact that you kind of pervade all of those rights, and so, but you will kind of approach them kind of at the same time, but all slightly differently. I think from the patents and the trademarks perspective, the key point is that they're registered rights generally. So you're talking about rights which have been registered at the relevant intellectual property office. So when you're approaching those rights, kind of your starting point is almost always that registration and looking at what is actually been registered, and what ensuring that kind of all the relevant formalities in regards to that have taken place. Whereas other rights like copyright, it's an unregistered right, and so it subsists kind of as soon as the work is created, which that varies by jurisdiction. So that's not quite the case in the US, for example, but in the UK that is the case, and so that adds a different type of complication, because you may not have in quite the same way something that you can kind of go to and say, this is the right, this is the thing that is protected, because it's nuanced and it may not be quite as clear. So I think that's probably one of the key differences in approaching the various rights, is whether or not they're registered, and how that impacts the way that you move forward.
Great, thank you. And then just sticking with you on this one, Luke, in terms of, I guess, aspiring lawyers looking to build that background knowledge and move into intellectual property, what would you say is, I guess, the background that's needed? Would you say it's necessary for students to have sort of a technical background, or if they're looking to get into more of a scientific side of intellectual property, would they need to have a scientific or an engineering background to do well in that area?
Yeah, I think certainly for like trademarks, copyrights, that side of the intellectual property space, there would be no advantage, no disadvantage to having that scientific background. It doesn't really pervade those types of intellectual property. From the patent side, I think it has its advantages and its disadvantages. So I'm not actually I don't have a technical background. I didn't do a science degree. I did a law degree. Many of my colleagues did science degrees of various different types. But often in many cases, actually the case that you get put on, the litigation isn't actually anything to do with the field in which you studied. So it may be you're lucky and it is an advantage, and you can read the patent or the relevant documents a little bit quicker because you have that background. But fundamentally, as Rachel said, if you're kind of eager to learn and you are keen to pick this stuff up, you can kind of teach yourself it, and you really get into the weeds on this stuff. And so you don't need to have that technical background, and I haven't found that it's hindered me at all. I think actually having that diversity is really an advantage, and having people who are both technically minded and also those who didn't have that background is an advantage, and I think law firms recognize that.
Amazing, thank you. And then I guess just sticking on that kind of topic, Fariha, could you tell me a bit about, I guess, experience and what experiences are necessarily useful for aspiring lawyers looking to set themselves up with a career in intellectual property?
I actually think all experience is good experience. And one thing I definitely found throughout my training contract is that even within IP, it's so varied, and for copyright and trademarks and designs and to patents, it's all so different. And I don't think there's any one experience that you could probably do as an aspiring solicitor that's going to tick every box. So I would say don't necessarily worry too much about getting specific experiences, but I think all experience is good. So as a trainee, we do a lot of you're kind of managing a lot of different things for the first time, such as general admin points as well, and then kind of getting on top of that on how to deal with emails and manage action lists and drafting things. And I think those skills can also be picked up in loads of different experiences, and it's something that you definitely take into your work as an NQ. You still have to do all of those things. So yeah, I would say all experience is really valuable, even if it's not specifically legal IP experience, because those skills are very transferable. And that's something that we always talk about at Bristows, but generally having transferable skills is really important, because even the skills that you might take from one matter you're working on, you might then carry that over to another matter, and that can be really helpful.
Amazing, thank you. And then back to you, Luke, on skills. Obviously, there's a lot of work across different sectors. Are there any particular sectors like technology or fashion where IP lawyers are particularly in demand? And would you say that influences the kind of skills or experiences that are useful?
Yeah, I think I previously had said about how it really is sector agnostic, but there are key sectors where it is a focus. And so intellectual property lawyers are more in demand. And I think that's right. Technology, life sciences, fashion, entertainment. In terms of the sorts of the skills that you would need to have or experiences that would be useful, I mean, I would certainly echo what Fariha said about it should be, all experience is good experience. Working in the hospitality sector is good experience that you can leverage to demonstrate commercial awareness or organization, et cetera, et cetera. And those skills you will pick up in any type of job and in all sorts of different types of experiences. And the difficulty often is just kind of demonstrating it and expressing how those skills have been developed. But in terms of how the sector influences the skills, I mean, I can't think of anything in particular. I think particularly having that interest, I really do think is the key point. You need to be really curious, really willing to get into the details of these areas, and that's the technology of the patent, or that's the brand that it has been built around the trademark, or the whatever it may well be. And I think having that commitment and that interest to really dive deep into an area and being curious in that way really is a skill that will do you well as an IP lawyer.
Amazing, thank you. Great. I'm going to move on now to talk a little bit about business development and sort of how different departments work together. I'm going to start with you, Rachel, if that's okay. Would you be able to tell me a bit about how the IP practice at the firm engages with the rest of the firm? Are there any kind of departments you regularly interact with, and does that link, I guess, to business development?
Well, absolutely. So I think, as we said previously, Bristows has got quite a big IP department. Generally, so it's got a big IP offering, and because there are so many of us, we actually are split into quite sector specific and also work specific groups. So Luke, Fariha and I are all in the patent litigation department, which is quite specific. We've got a department to deal with brands, copyright, trademarks, litigation. Then we've got a commercial intellectual property team, and that I think is quite unusual in a city law firm. That said, we do still work with the other departments a reasonable amount. One of the key areas of overlap here at Bristows at the patent litigation department is actually with the competition team. So particularly on the tech side of things, which is what I specialize in generally, there are quite a lot of licensing disputes, and the patent litigation flows from a licensing dispute. And so at Bristows, there's lots of overlap between the patent litigation team and the competition team when you're talking about the terms of a license to license out these patents to various people. We also do some work with the corporate department. That tends to be specifically if there are issues of IP infringement that have been highlighted in a big due diligence for a big sale or a merger or something like that. But I think generally, perhaps in firms where it's not quite so divided in terms and specialized what you do, I think that there is a lot of interplay between the intellectual property department and lots of other departments. Intellectual property departments do a lot of transactional support work, but then also their own standalone litigation work, and it can be for any sector and any of the particular IP rights. And in terms of business development on that, it means that whenever you are meeting a new client, you always have to be aware to actually explain not only what you offer, but what the rest of your firm offers, because obviously them having access to a team that's fully integrated in other areas of the law is always a benefit to them.
Definitely, that makes sense. And there's definitely a lot of I guess when you've got such a wide team, there's so many opportunities to sort of cross-sell that and look at how other teams could help out your client too. So yeah.
Oh, absolutely, because it's always good for a client to have actually a more full service, and so being well kept up to date with what's going on in other departments and what's going on in other areas of law is always helpful for when you're looking at developing your business, expanding your practice, that kind of thing.
Amazing, thank you. And then Fariha, would you be able to tell me a bit about, I guess, have you had any chances to sort of start to get involved in business development at an early stage, whether that's kind of in your training contract or in recent months?
Yeah, there's loads of opportunities, I think, both within patent litigation team, but also more broadly the firm, to get involved in marketing and business development. And I think it's something that we're always like quite aware of. And that can be in the form of like writing articles, which is like a really great way that as trainees we do it a lot, but I think it also goes into like associate level as well, where we do kind of articles which are like case updates or summaries or anything that's really going on in the IP world that is quite relevant to our work. We do articles, which is a quite nice way. I think as a trainee, I quite like that because you get to read into something that's quite important, and then you get to draft something as well. And by the end of it, you know quite a bit. And then we also do, Bristows does a lot of podcasts as well. So I know we've got a friend podcast. We've also got a UPC podcast. And again, those are done by like different people across the team. So there's definitely opportunities to get involved in kind of business development, and it's really encouraged. And yeah, so both at trainee level, and I think it continues well into while you're an associate as well.
Amazing, thank you. And Luke, did you have anything to add on that in terms of, I guess, how you get involved in business development, or anything about how the firm interacts across departments?
Yeah, absolutely. In terms of business development, I think what's really important is kind of building strong relationships with our clients, and that happens at all levels. I think there is a perception that it's the partners who are constantly kind of talking with and taking instructions from clients, but a lot of our clients are really big and they have big legal teams, and so they also have junior lawyers, and so it's important. And what we do is we try and make sure that we are kind of interacting with them and helping them as junior lawyers, helping our kind of partners within the client. And that's good because as time moves forward and they become more senior and we become more senior, of course, if you've already established that relationship, that's really helps in terms of being able to properly advise them, to understand their business and understand how they like things to be done. So there's that aspect, and that often, for example, when we're visiting our clients or when our clients are visiting us, we make sure that we've kind of got a full team of all levels there so that interaction can happen. And similarly, there's networking events. So another way of doing that BD is going to, for example, we're hosting an event in a few weeks, and there's kind of drinks before and there's going to be drinks after. And so we'll be able to come down to that and speak to clients, chat to people, and kind of start building that relationship and getting to know people. Even if they are the more senior people at our clients, we can still have that opportunity to talk to them and to get to know them. And then in terms of across teams and within the firm, working with those other teams at Bristows, it is really varied. Like, you really do work with lots of different teams. One of my cases at my previous firm was a big case that involved our employment team, because essentially our client had alleged that an employee had stolen some code, and was basically, it was kind of a combination of an intellectual property infringement and also a dismissal case. So we had to work really closely with our employment colleagues, to kind of sculpt that case and to work on that case. So there is a lot of work across teams, and as both Rachel and Fariha said.
Fantastic, thank you. Great, so now I'm going to move on to focus on future trends and I guess hot topics. Just to start with you, Rachel, could you just give me, I guess, as a starting point, a bit of an insight into what the key issues are at the moment impacting the practice area?
Well, there are always new cases coming down, which are, throwing new things into the mix. I think one of the key topics that particularly people in patent litigation in the UK are contending with is actually something that Fariha mentioned just now, which is the Unified Patents Court, which is a pan-European court that's been up and running for a few years now. But often if your practice base and your client base are international, then actually what's going on in Europe, and in particular in the Unified Patents Court, can have quite serious ramifications on your clients. So that's something that's quite big, I think, now for all patent litigators. In particular, a recent case which expanded the remit of the UPC's long-arm jurisdiction, which I think has got lots of patent litigators thinking, goodness me, we're going to have to tackle this at some point, I would imagine. So it was a case from the CJEU, which essentially said that the UPC can rule on infringement and validity of patents in non-UPC designated member states, which has caused quite a ripple effect throughout the legal community at the moment. So that's one big development, for example, but there are always lots of different developments.
And then I guess as those developments take place, Rachel, what sectors would you kind of expect to see more IP work in the coming years?
Well, I honestly think it was kind of been a theme actually of this whole talk, is that actually at the moment all sectors seem to be producing more IP. I am particularly interested in the green energy sector. A couple of years ago, I did a case on wind turbine technology, which was just absolutely fascinating. And so that's something that I'd be really interested to look at further. And I think as people are more aware of kind of trying to become more carbon neutral, then I think that there's a huge drive towards kind of carbon capture, electric vehicles, hydrogen cars, waste management. All those kind of technologies are just creating so much IP. So I would imagine that they would be somewhere that's going to be driving quite a lot of IP work in the future. Similarly, the famous Blue Origin flight earlier this year shows that private companies are trying to get into space tech, and space tech is ripe for lots and lots of IP and lots of really interesting inventions coming out of that. So, I mean, those are just two areas, but I think that, you know, pharmaceuticals, there are always new things with pharma cases, kind of bioengineering and all that side of things. They're all exploding intellectual property wise.
Amazing, thank you. That's really interesting. And then I guess sticking with the topic of technology, to touch on AI, Luke, could you give a bit of an insight into the impact AI has had on your practice, and has it created any challenges, I guess, and if so, how do you look to overcome these?
Yeah, I think, you know, as with everything, it's starting to pervade everything and everywhere. You know, when I qualified, you know, the concept of using AI in any type of work would have been completely alien and just not done at all, and that was not that long ago. It has happened so quick, and it has developed so quick, and fundamentally today is the worst it will be because it's only getting better and better and better. I think, you know, personally, you know, my view is kind of trainees, newly qualified lawyers and juniors, you know, this is now a part of your job, and it's the same as knowing how to properly use Outlook and how to properly use Microsoft Word. Like, you need to understand this technology, and you need to utilize it to be the kind of best lawyer that you can be. And, you know, however many years ago when email came in, if you were the sort of lawyer who said, well, I just want to send letters, you know, you would have just been laughed at. And I think that's going to be the future as AI gets more developed and gets more utilized. In terms of the impact, I mean, it's interesting. I think, you know, once you understand how to use it, you can see its strengths, and you can utilize those strengths to be a much more productive, quicker lawyer. I think it's very good at sort of admin-y tasks, which aren't particularly fun. So I think there's a real opportunity there for juniors in particular, where they can do those tasks quicker, and then they can really start to focus on the more interesting stuff, the more exciting analytical work that the AI at the moment isn't able to work with and isn't properly able to do. The challenges, I think, are knowing how to use it properly. You know, it is a skill to learn how to use this technology, and also appropriately, because I think, you know, we've seen these cases of people clearly using AI to, for example, write trial briefs, and then just not checking them, not properly doing their due diligence, and just using it, and then it's making things up. and they're having to go into court and say, oh, I don't know where this came from. And, you know, it's not a good position to be in. And if you're not properly using this technology and properly checking what this technology is doing, you know, those risks are there. And of course, those risks are massive because, you know, the judge isn't going to be particularly interested in your excuses. They don't, you know, they're just not going to be happy with this sort of laziness, really. And I think it's in terms of overcoming those sorts of challenges, it's really understanding what this technology is. What is it good at? What is it not good at? Where do I need to be really checking over what it's doing? And how do I utilize it in a way that does kind of improve my efficiency, improve what I'm doing, but without risking kind of catastrophic mistakes like incorrect citations or made up citations.
Fantastic, thank you. And then, Fariha, could you tell me a bit about how you stay up to date with key developments and hot topics, either in kind of, I guess as well, how you'd recommend like aspiring lawyers, people doing applications, should sort of, I guess, boost their commercial awareness as they're doing research?
I definitely think it's like an ongoing thing. I remember when I was a trainee, or at the very start of my training contracts, you like sometimes when you get the training contract, you think, oh, okay, like that's it, like I've done the commercial awareness, but it's like it's constantly ongoing. And if anything, you need to get better at it as you go along. But I would say for me, the ways that I prefer to like keep up to date, and I think it's becoming easier, is definitely podcasts. Like I said, Bristows has quite a few, but even outside of that, you can definitely find podcasts on things that you're interested in terms of like we've got a UPC one now, and that's quite interesting, particularly because if it's an area that you don't necessarily know that well, sometimes listening to someone else talk about it is a lot easier. So you can do that even on your commute. I also find it really helpful just to keep generally up to date with the news, see what's going on, so you can see what, even if they're not your clients, what other companies out there are doing, because that's also really helpful just to have an idea. And also, there's so many things that you can sign up to, like alerts. So I have quite a few, like you get updates from like PLC, and you can also read what other law firms are also doing. So that's also a good way to know what is coming up, what is likely to happen. But I think it's just a matter of keeping up to date because all the information is quite easily accessible. I wouldn't, like as a trainee, we didn't, or even before getting the training contract, like you don't necessarily need to invest in loads of subscriptions for different things. You can find all of this information quite easily. And you just need to keep up to date. And I think that's the best way to build your knowledge. So sometimes, like as a trainee, I tried to keep a habit of kind of every morning just spending 10 minutes going through the updates, like the email updates that I get, or reading like an article on some of like the IP websites that are quite popular. So I would just say just reading, keeping up to date, simple things, but as long as you make them a habit, I feel like it helps you in the long run to know what's going on and to also know what people are talking about around you as well.
Fantastic, thank you. That's really great advice. Amazing. Moving on to our case study, which I believe Luke and Rachel have prepared, a short summary of a recent case, or a typical case that they would work on.
Okay, yes. So this is a case that Luke and I worked on for a couple of years ago, although actually at that point we were on different sides of the case, so that should give kind of a nice angle to this case study. It was actually stemmed from a big licensing dispute between a Dutch multinational and a Chinese tech, two Chinese tech companies. And it was in relation to patents covering mobile phone technology. You may have gathered from kind of the lilt of my discussion is that I focus quite heavily on tech side of things and mobile phones being my bread and butter. Sorry, there's just... So essentially, as often happens with mobile phone cases, mainly what parties want is a license. And part of one party, normally the patentee, will want high license fees, and the implementer will not want low license fees, which is understandable. And so if they can't come to an agreement, they will go to court. And part of that at the moment are patent litigation proceedings, and also proceedings where they ask the court to determine something called a FRAND license. And this actually ties quite nicely in with what we were saying about the fact that IP law is just all-encompassing, really, in the world that we live in. So the reason that your phone from Apple can talk to a phone from Samsung is because all the technology within that phone is standardized. So they all have to follow the same rules and procedures and use essentially the same technology in order to be able to talk to each other and talk to the network. These standards are set in big standard meetings, essentially, where all the key players in the mobile phone industry will come and they will say, oh, well, actually, I think my technology should be incorporated for this part and my technology should be incorporated for this part. And of course, all of those technologies are covered by patent rights. So then you have a situation where actually everybody has got to use these patented technologies. But how can you make sure that they're actually not being illegitimately charged far too high prices for the fact that they have to use this technology? And that's where this concept of a fair, reasonable and non-discriminatory license came in. So that's kind of gives the background of the case. The problem with this side of with FRAND licensing is that even after multiple judgments in many years, it's still not hugely clear what constitutes such a license. But that kind of gives the background of what I was involved in, which was actually the patent side of things. So my client had a patent that it said was being infringed because it was being used in this standardized technology. And the other side said, actually, this patent is invalid and we don't infringe it anyway. And so we put forward our particulars of claim and our particulars of infringement, and they came back with a defense and counterclaim. And you kind of go on like this. You have your expert reports that are exchanged, and then you read the other side's expert report and decide what you do and don't agree, and then put secondary expert reports in, and then get to trial. And I think kind of that followed like a typical progression for a case. Without going into lots of really possibly mind-numbing detail about how various bits of the mobile phone technology work, that's probably the overview of a patents case on the tech side. I don't know, and Luke, do you have more to add to that?
I think that was, that sums it up really, doesn't it? I suppose on the kind of the problems and the difficulties, it's that difficulty of how do you determine what's fair and reasonable? How much of the value of a particular phone comes from one particular patent when there may be 100 patents that kind of protect the various technology in that phone, and that's where it becomes really difficult. One way that the courts have tried to do it is to essentially look at all the other license agreements. So, for example, that Dutch multinational no doubt has licensed out to lots of other tech companies. So the court might ask all those tech companies to disclose all their license agreements, but then, of course, they don't want to disclose it because they don't want their negotiated positions to become public knowledge or even knowledge to their competitors. So that you then have this really complicated scenario where you have confidentiality clubs, so only certain people at certain clients can see certain documents, and it all becomes very complicated, very interesting, and really good fun.
Well, from that you can also see how these cases just snowball and become huge and have so many different parties and so many different layers of confidentiality clubs, technical understanding, different experts for different areas. You'll have potentially an economics expert. You obviously have your technical expert for your technical side of the case. They can really balloon in that sense.
Amazing. Thank you both. That's really interesting. And then I guess now I'm going to move on to audience questions. We've got quite a lot of that have come through, so I'm just going to. Oh, no worries. I thought you had your hand raised. Yeah, I'm just going to look at some audience questions. We've had quite a few come through. The first one I'm going to touch on is, has the emergence of complex technologies made patent litigation more challenging? Does anyone have any thoughts on that?
Did you say of complex technologies?
Yeah, complex technologies.
Oh, I think if anything, it makes it more interesting because you have to get to grip with those technologies. So unless I've misunderstood the question, I don't think it makes patent law more challenging. We are at the stage now where there's huge granularity in terms of actually the bits of these technologies that you are litigating. It will be highly specific. So, for example, in this, in the wind turbine case that I was working on, it was one specific mode of the turbine that was the feature of this patent. It was something called low voltage ride through, and obviously the turbine has got lots of other functionality, and there are huge amounts of things that go into making a wind turbine work, and we were looking at one very, very small part of it. So actually, as technologies get more and more complex, I imagine it just means the patents will get more and more granular and more specialized.
Great, thank you. And then I've got another question, which I think is kind of off the back of something that Luke might have said earlier, but obviously you can all chip in. But it's about the science background and the technical background. And this question is, if you're coming into this sector from a non-law background or from a non-science background rather, what kind of support is available to help you get to grips with that technical side of things?
Yeah, I mean, I suppose, as a starting point, all your colleagues are there, right? So, we're very fortunate to have colleagues who do have that science background. So if I have a silly question about a particular type of technology, I can go and ask my colleagues, and they're absolutely happy to help. The other aspect of it is that a lot of what we do, as kind of Rachel alluded to, is talk to experts. So we spend a lot of time not just trying to understand this by ourselves and on our own, but actually on calls with kind of leaders in the field, so professors from universities, and we'll have calls with them. So there are elements that you don't understand, you can ask them and get a free, well, not free for us, but not for the client, lecture on about that particular technology. So you can kind of ask them and query them and say, oh, I haven't quite got my head around this, could you explain it to me? And they're always happy to help, and they're always these people understand these technologies very well, and their jobs generally as lecturers is to write about and to explain them. So they're very good at doing that. So you can, there are lots of resources around. Apart from those kind of asking others for help, essentially, of course, you can do your own research, and there's, today on the internet there is so much information available that you can, certainly get a starting point from the internet, and then really build on that with that support from others.
So thank you. It's good to hear. I guess that there's lots of different avenues for that and lots of different support at the firm. The next question, which I think looks quite good, someone's asked about cross-border work. They said, I know Bristows has European offices. How much of the work would you say is cross-border?
I'm happy to start with that anyway. As a starting point, IP rights are generally they're national rights, so they're actually they're kind of siloed within the country, as it were. But that doesn't mean that as a field it is a practice where you will not be involved in international work. In fact, quite the contrary. A lot of our work is coordination, and it's working with our colleagues and lawyers across the world to make sure that strategy, for example, is consistent across the world. So we'll work with lawyers in India, in China, America, Europe, all over, just trying to ensure that those rights for our clients are being kind of enforced and used in the best possible way. And that can involve, I've traveled to Norway to teach, or not to teach, but to help our Norwegian lawyers understand particular parts of our technology. Traveled to trials in the Netherlands. I've been to trials in Belgium. Like, it really is a very international field, and there's lots of work across borders.
Amazing. Did you have anything to add to that, Rachel?
No, I mean, that was what was I was going to say. A lot of our work involves coordinations, because at Bristows, and I know this is the case in lots of law firms across the city, our clients are multinationals. And so actually whenever a big IP dispute starts, it won't be starting just in one jurisdiction. There will be disputes in multiple jurisdictions. And therefore, as Luke was saying, you have to make sure that you are coordinating your strategy across all those jurisdictions. And that's very interesting. It's interesting to see the slightly different minutiae of the law in all the different jurisdictions and the way that courts approach things. So you will rarely get a case that just has one kind of jurisdictional aspect to it.
Fantastic, thank you. And then one final question is that I've seen, I think it's good, which is someone's asked what the sort of working environment and I guess work-life balance and working environment is like in the IP team at Bristol, and what, I guess, just a flavour of what it's like to work in your team.
I think generally Bristows is really, really great for its culture. So having rotated through quite a few departments, I think it varies on what you're working on. And I think all lawyers will probably agree that if you're just working on something super busy, you might just be working a little bit late that day or that week. And that's kind of unavoidable, because if you've got court the next week, you need to do the work. But then having said that, we always have quieter periods as well. So like, I know over August, sometimes it's a little bit quieter because the courts are closed. So it really varies. And I think it also depends on if you're in active litigation or not. So overall, I think Bristows is really great. We're encouraged to kind of have a good work-life balance. So, people will, if they're done for the evening, they will leave. You don't necessarily need to hang about just for the sake of it. So, and we have loads of things going on as well, like socials and things. So we're always encouraged to like get involved in the culture and be a bit more social. So I think Bristows is really great for that, but it does just depend on what you're working on. And I think that dictates the hours you might be working that day or that week.
Fantastic, thank you. And then I guess just to wrap up, would you each be able to give me just a short piece of I guess, closing advice? What would you say to someone who's considering a career in IP? What advice would you give them? Can I start with you, Luke?
Yes, absolutely. I think I would say that it's, really seek every opportunity you can to learn as much as possible. I think if you can kind of go into that application process or that interview with great examples of why law, why that type of law, and why that law firm, those are the three questions that you need to kind of find your answers for. And how you do that will be different for every single person, and the types of experience that will feed into that will be different for every single person. But if you can answer those three questions, I think you're generally in pretty good stead.
Amazing. And Rachel?
I think, mine ties in very closely with what Luke has said, and with what I've previously said, which I think is just be curious. Be interested, be enthusiastic. People love to talk about what they're working on. They love to talk about what they know. And if you can be a sponge and just take in everything that they're saying, and that can help you decide what area of practice you might like to go into. I think keep an open mind, because you might go in thinking, oh, I definitely want to be, a pharmaceutical litigator, but actually you then might realize that actually you find it much more interesting drafting contracts all around protection of trademarks. I think it's such a broad area that don't go in with really set views on exactly what it is that you want to do.
It's great advice. Thanks, Rachel. And then finally, Fariha.
I think I agree with both of what Luke and Rachel have said. But just to add to it, I think the only thing I would say is from a more junior perspective, I think everyone's journey into where they are now is very different. And I would say, I wouldn't worry so much about what stage you are, and it's more about figuring out what you want, and not everybody's journey into the profession is the exact same. I would also say be open-minded, like Rachel said. You might, it's one thing I found was that keeping an open mind helped me make a decision that I was happy with. And sometimes coming into things, you don't always have the full picture until you are here and you're doing the work, and then you can figure out what you like. So I would say my real two pieces of advice would be open-minded, and just don't compare. Like, keep going. It's an intense journey, I think, being a junior coming into law, but yeah, if you have the right motivations and you can answer the questions like Luke said, then you're in a good place.
Amazing. Thanks so much. Great. So I'm just going to finish off by launching a final poll just to get an idea of what people's key takeaways are. Just while people are voting on that, I'll just also highlight again that this recording will be sent around to everyone that signed up. I think I saw a couple of questions about that in the Q&A. And then this will also be uploaded to YouTube, so you'll be able to watch that back as well. So just keep an eye out. There's also going to be a survey popping up once the masterclass has ended, so please do fill that out and let us know how you enjoyed today and what other topics you'd be interested in us covering in the future. Great. I'm just going to end this poll. Looks like we've got a lot of people who've said they understand a lot more about what the work of an IP solicitor involves. And yeah, people have also learned about breaking into the practice area and the key issues affecting the practice area right now, which is fantastic. Great. So just to wrap up, just want to thank our panelists. You've all provided some really great insights. Thanks so much for your time. And thanks for all of the attendees for coming along. We look forward to seeing you again at our future masterclasses. Please remember to take a look at our events page to sign up to any future masterclasses. Amazing. Thanks, everyone.